Okay, so it is 7:30, so we're going to get started. I'd like to just start by saying good evening and welcome to this session on assessing IP and TPD Medicolegal claims. My name is Sue Larson, for those of you who don't know me, and I'll be your facilitator for this evening. So if you are a medical expert who currently assesses injuries related to superannuation and disability insurance claims, or if you'd like to be one, then you've come to the right place. This webinar is for you. Like other medico-legal assessments, IP and TPD claims are heavily reliant on the medical evidence that you provide. So in order to deliver a reliable report that you and your referrers can have confidence in, it's important to have a good understanding of how these claims work. Tonight, we are really fortunate to hear from Annemarie Gambera, practice leader of superannuation and disability insurance at Slater and Gordon, who has more than 20 years experience in insurance law. She'll be sharing her expertise and understanding around IPD and TPD claims, and in particular, who is eligible for these kinds of compensation. How do these entitlements work? What are reasonable kind of amounts? What do they actually look like? Who pays? How are they paid? What is medical attendance? What's that all about if you receive a request for medical attendance? We're going to be then honing in on the work that you do specifically, which is around the medico-legal assessment itself. So what is the purpose of it? How do you assess them? What's the benchmark that you use? And what is it about the policy and the definitions that are so important in driving your responses to the medico-legal IP and TPD assessments? We're going to be looking at some typical questions and responses. We're going to be discussing the role, if any, of the AMA guides and whether you actually need to be accredited to do these kinds of assessments. We're going to be looking at, recourse for you, liability, what about your opinion? What if something happens, and you're called to the stand? What does that look like? And we're also going to be looking at, from Annemarie's 20 years of experience, where do reports go wrong? Where do they cause problems? And what makes a high quality report? Now, if you would like to ask questions throughout, of course you can. Please feel free to put questions in the question box. So down the bottom, you'll see a Q&A. Feel free to double click on that and it will open. You can write questions in that box. You can also write questions in chat. So if you have any issues regarding audio or visual or issues like that, we have a tech team on standby who can help you out with that. Now, we will be pausing at various points throughout the presentation to regroup on the questions, and then I'll be asking specific ones to Annemarie as we go through the webinar tonight. So without further ado, I would like to invite Annemarie to share her insights and her expertise with us. Welcome, Annemarie.
Thank you, Sue, and thank you for the opportunity to speak tonight, and thank you to the attendees also. I hope that you get something out of this by the end of the presentation. So just by way of introduction, the purpose of this presentation is to give you a brief overview of these types of disability insurance claims and the connection, as Sue said, with medical evidence. So what I'd like to do is to take you through initially the types of claims that can be made, what the relevant criteria is typically for these sorts of claims, and then of course discuss the medical evidence that is needed in support of the claims. So Sue, if I may have the next slide, please. So firstly, income protection and total and permanent disablement claims. They're the two types of disability insurance claims that I'm going to focus on this evening. There are, of course, trauma benefits that some policies have, but we can just touch on them briefly later on. But the primary purpose of tonight's presentation is to discuss, as I say, these types of disability insurance claims. And the first thing that I'd like to point out critically is that these are, in fact, not compensation claims. So they're not like workers' compensation claims. They are not like motor vehicle accident claims. They are not personal injury claims. As Sue said at the outset in the introduction, I'm an insurance lawyer. I'm not a personal injury lawyer. I've never done any workers' compensation work. I've never done any transport accident commission work, medical negligence, etc. I don't need to, because these are insurance benefits payable pursuant to an insurance policy, and they become available either because someone has taken out a retail policy or private policy themselves with one of the major life insurers, or most commonly, they have become available to the members of a superannuation fund. So everyone who works, of course, and is over a certain age has superannuation, or should have superannuation contributions paid into a superannuation fund, and through the member's account balance, so your own money, premiums are deducted so that the member can receive the benefit of insurance cover for income protection and total and permanent disablement claims. It is automatically provided to most people. I'll talk about the exception to that in a moment. And it is provided on what's called an opt-out basis. So simply because you are a member of Australian Super or Legal Super or Rest or HESTA or Care Super or BT Super, you, if you look at your superannuation statement, likely have this insurance. You may not have income protection insurance through a group life policy, but you will likely have total and permanent disablement and death cover. So have a look tonight when you get home at your superannuation statement, and I will bet that most of you, if you haven't opted out, of course, and there are some other exceptions, which we'll talk about in a moment, you will have total and permanent disablement cover. And as I say, it is paid through your own money. So if you have a look at your superannuation statement, you'll also see that there is a monthly amount deducted for the premiums. And so the account balance will go down modestly because the cover is relatively cheap because it's provided to the entire group of members of a particular superannuation fund. So who pays when I'll get to that in a moment. I'll talk about the exception to the eligibility of people to whom cover can or can't be provided. So up until the 27th of October 2018, people under 25 or between 20 and 25 were given this cover. However, on effective the 27th of October 2018, there were changes to the law, which means that insurance is no longer automatically provided to new super fund members aged under 25 unless the member works in a dangerous job. The reason for that is because the reason for the change in the law is because it was considered that those people under 25 are usually at less risk of making a claim. They usually are earning less money. So it is considered by the government of the day at least that it was more important for their account balances to be protected rather than premiums for insurance cover being deducted. The insurance cover can be provided, but it's on an opt-in basis rather than automatically provided and then the person has to opt out. And there's also an exception for those people who are new superannuation fund members who have balances under $6,000. However, again, they can also opt in. So available in terms of eligibility, available to pretty much anybody except those under 25s with the option to opt in to cover. There are some exceptions. For example, people in armed forces are typically excluded from cover for what might be considered obvious risk that they're more likely to lodge this type of claim. Next slide, please, Sue. So what are these claims and who pays? So the who pays is the insurance company. It is very much like a car insurance policy. Premiums are paid, an insured event happens, the insurer pays on the satisfaction of the relevant criteria and in consideration of whether there are any exclusion clauses, which we'll touch on briefly in a moment. So firstly, what is income protection? As the name suggests, they are payments if you're unable to work. They are payments to protect the income that you've lost because you are injured or ill and are unable to work. They are paid on a monthly basis. They're available for a fixed period of time, usually 1, 2 or 5 years, but there are some policies which do go for much longer to, for example, age 65 or 67. And they usually cover, well, there's a difference between indemnity policies and agreed value policies. So mostly with policies through a superannuation fund membership, they will be indemnity policies. And what that means is that the insurer will only pay the pre-disability average earnings based on the gross income at the time of claim. And that is pretty tricky for a lot of injured people, because as you would know better than I, when a person begins to experience ill health symptoms, they don't necessarily cease work that day or that month. What often happens, more often than not, is they continue to do some work, and then those symptoms might become worse, they're aggravated, etc. And then ultimately they make a decision that they can't continue in their work role anymore. That's problematic in terms of the amount payable by the insurer, because having reduced their hours, for example, their gross income will have decreased. And that's what a lot of people don't understand, that they will not receive the amount of income that they were earning, say, 2 years, 3 years before when the symptoms started. If a person has an agreed value policy, which is more likely if a person has taken out that policy themselves through a private scenario, that ring those ads, real insurance, etc., then the amount of the benefit payable is that agreed at the time of application for cover, not as at the time of claim. So again, it's like a car insurance policy. You might have agreed that your car is worth $70,000 and that's what you'll get paid. Whereas if you haven't agreed, then you'll get, for example, the market value at the time of the claim. So it's very, very similar. And as I say, it's the insurer who pays this. It's an insurance policy. The insurer pays the income protection amount of usually 75% of the pre-disability average earnings based on the last 12 months of income prior to the date last worked. They pay that directly to the claimant, and if it's a superannuation held policy, so the superannuation fund is the policy owner, but the members are the beneficiaries of that policy, they will pay on average 10% into the super account balance. So your super account balance grows by what would otherwise be a superannuation guarantee contribution payment. Offsets usually apply. So if a person's on workers' compensation payments, for example, or social security payments, or any other form of compensation payments, not always, but usually there is a dollar for dollar deduction. So people cannot double dip, basically. And typically a waiting period applies, so there is no payment usually for a specified period of time. So for usually between 30 to 90 days, there's absolutely no benefit payable during that period. Next slide, please, Sue. So what does one need to do to be successful in an income protection claim? Throughout our chat this evening, you will probably hear me say a lot about the policy is king. So what is required for a successful income protection claim is whatever the policy dictates is required. So there will be definitions of things like being totally unable to work, or temporarily unable to work, or partially unable to work. So in order to be successful in an income protection claim, the definition of total disability or partial disability or temporary incapacity will have to be satisfied. And if it is not, there'll be no benefit payable. So I've just reproduced for your assistance a typical definition of total disability or totally unable to work. It's the same thing, just different language. So normally what's required there for a successful income protection claim is that the person has suffered an illness or injury which has caused them to stop work, that they're totally unable to work in usually their own occupation for a specific period of time, usually 14 days. They're not working, and they are following the advice and treatment plan of a medical practitioner in relation to that sickness or injury, and they're unable to perform all the duties necessary to generate income of that occupation. That's a typical definition. There are some differences. For example, some definitions say not working, following the advice of a medical practitioner, and unable to perform at least one income-producing duty of their occupation. Then there is also the partial disability definition, which dictates that for a successful claim, while that person is able to work, they cannot work to the extent that they were working previously. So that is what's required for an income protection claim to be successful, the satisfaction of the criteria in the policy of whether a person is able to work at all or at least to some extent. So one always looks to the definition. Really, it begins and ends with the wording of the insurance policy. So I hope that through my discussion with you tonight, if you are someone who is doing a lot of workers' compensation related medical reports, you'll begin to appreciate that there is such a critical difference between those sorts of claims and these. Those claims are based on things like the Accident Compensation Act, or I think there's a new name, the Transport Accident Related Act, pain and suffering. There's none of that here. There's no discretion. It's a fixed sum, whether it's income protection based on an agreed or indemnity value, and also similarly with TPD. So there are really some critical differences, and as I explained to our workers' compensation clients who come to us, the only real connection is that there's been an injury or illness and the person isn't working or can't work either completely or to some extent. That really is the connection. It's just not the same thing at all. Next slide, please, Sue. Some exclusions apply, again, in terms of eligibility. If a person is, for example, has become ill, but their illness has arisen directly or indirectly, for example, because they've been deregistered from their occupation, then irrespective, that is going to be an exclusion that is upheld, and there will be no benefit payable. There are other exclusions, for example, self-harm, suicide attempts within usually 12 months of the commencement of cover. There'll be exclusions, and whether the person satisfies that type of criteria that I mentioned earlier, they won't get paid. There'll be no, they won't be eligible. And the other one also is if there's no income to protect. So if a person has been unemployed for some time and then they suddenly become ill, well, you weren't earning an income. So again, this is all to protect the income that you're otherwise earning. But if you've been unemployed, you have not been earning an income. So there's an ineligibility issue there as well. And of course, then there's the offset issue. Sometimes these income protection benefits are fully offset by the benefits payable under another scheme, for example, a compensatory scheme or a social security scheme such as Centrelink. Next slide, please.
So we've got a few questions that have come in, Annemarie, that I might put to you. I probably have the first one because I know I've had conversations with insurers and lawyers around this, and that is that just honing down on the total and permanent disability, where I know that often there have been questions that have come in around the report saying, well, the person, is not able to do the entire part of their role. Well, that's not total and permanent. They have partial, injury that affects their role partially, but they're not totally and permanently disabled. So I guess that's where the question is, if they're asking about total, are they totally incapacitated from doing the role? That's where the definitions and the questions will really guide the response. What happens if they can do 50% of the role? How should the medico-legal expert deal with that?
So there are differences with respect to income protection benefits and total and permanent disablement benefits. So we're going to come to the total and permanent disablement in a moment. But in terms of just focusing for the moment, because we've just been talking about income protection, if a person can do 50% of their role and they have got income protection cover, then they will likely be eligible for a partial benefit. So they'll get something as long as there are not offsets that disqualify whatever the benefit was payable. They'll get something. But it is different for total and permanent disablement. So if we go to the next slide,
I've got a couple more questions for you before we move on to that one. This first question is from Dr. Philip Sharp. Then we've got a question from Dr. Tom Rosenthal. So from Dr. Sharp, what happens if a person doesn't want to follow the medical advice? How is it dealt with then?
That's a really good question. In terms of the medical advice, usually it does refer to reasonable medical advice. So the person doesn't have to, unless it's a very broad definition like the one that I just mentioned there, the person doesn't have to undergo every single modality of treatment available in the world, usually, to satisfy these claims. It has to be reasonable medical advice. That's the first thing. And the second thing is too, some people, of course, because of religious reasons, for instance, or cultural reasons, will not follow medical advice. And they are arguable points to challenge any rejection of these types of claims. Now, if there aren't any such qualifications, such as religious or cultural, or even fear, for example, if a doctor recommends that surgery should take place, but the person is very fearful of surgery and has a genuine fear, then again, if an income protection claim was rejected on that basis, as a lawyer for that kind of claim, I would challenge that if it was a genuine fear. And we've had those types of claims where we have been able to get up on them, and I'll talk about trials briefly later on. But if it is reasonable advice and there is no qualification, for example, religious, cultural, etc., and the person just won't follow it for whatever reason, then that claim will be declined, and reasonably so.
Okay, thank you for that. I'm going to open the mic for Dr. Tom Rosenthal and just allow you to talk, Tom, so putting you in the hot seat. So, Tom, you are free to speak. I'm going to ask you to unmute. Dr. Rosenthal, your microphone is muted, so I've just sent a request to unmute. Okay, we might move on. Dr. Rosenthal, if you've got a question, feel free to pop it in the open questions. Just a couple more questions that have come in from Dr. Padmashri Kadam. If the person's ability to avail treatment is impacted by exhaustion of health insurance cover, should it impact in IP claim review?
Perhaps it shouldn't, but it will. So if a person cannot financially afford medical treatment, unfortunately, that doesn't usually get them over the line, because it doesn't say in the definition, well, if you can't financially afford the treatment, you're okay, we'll pay you. It's not that sympathetic.
Okay. All right, great. We've got a couple of TPD questions that have come in from Dr. Vinit Mathur and Dr. John Garvey, so we might move forward to the TPD, and I'm going to save those two questions up, but keep the questions coming through. Thank you for that, our wonderful webinar attendees, our participants. I'll save those two up for this section. Annemarie.
Thank you. So total and permanent disablement claims. These, as I said before, these are lump sum benefits. They range usually from around $10,000 to $1 million. So they can be even more than what a person would get in a workers' compensation claim for, a fairly traumatic injury. And they, again, are paid exclusively on the satisfaction of the criteria in the policy of insurance which provides the benefit. Again, as I said earlier, just by way of background, most people do have this entitlement through their membership of the Superannuation Fund. These claims can normally be made in addition to other compensation claims that can be made simultaneously in most states. The only exception, I think, is the Northern Territory. And we do these claims all the time simultaneously with, we'll have our workers' compensation team of lawyers deal with a workers' compensation claim while we do a total and permanent disabled claim. That is really, really common, and more common than not. The typical definition, I've really summarised it here, but what it normally is again, an illness or injury has occurred. That illness or injury has prevented the claimant from working either in their own or in any occupation. It depends on, again, the wording in the policy, for a consecutive period, usually 30 or 60 days, and this is part usually of the criteria in the insurer's opinion. They're clever enough to include that as part of the criteria. In the insurer's opinion, that claimant is unlikely ever, and I wish to underscore the word ever, and I'll come back to that, to return to work within that person's education, training, or experience. The word ever means compared to a typical working life to age 65. So when a doctor is asked to give an opinion in a medical report, they should be looking at the definition. They should be presented with the definition, and they should be thinking about, well, this person, my patient, or this person I'm examining, is X years of age. If that person's 20, it's going to be much more difficult for that person to satisfy this definition, because they've got a potential working life to return to work 40 plus years. If a person is 64, it's much easier to call it. And it is definitely crystal ball gazing. I appreciate that. And then the other issue here is, what is education, training, or experience? Education, training, or experience is the vocational and educational background that claimant has had to the date of claim, or, again, depending on the definition, to the date of assessment of the claim. And often, because Australian Super is the largest superannuation fund, it has a really tight definition, a really harsh definition. It actually includes in its definition that education, it will consider education, training, or experience which the person can do with retraining or rehabilitation. So it's very hard to satisfy that. But nevertheless, what a doctor should be thinking about when considering a medical report of any description, be it a medical attendance statement, which we'll talk about briefly in a moment, or a medico-legal report, is there a link, some sort of connection between the person's vocational and educational history to the date last worked compared to other jobs? If there is no link, then that person is not qualified or fitted or reasonably suited, they're the types of phrases, to work in that other occupation. That is not within their education, training, or experience. So, for example, insurers may often say things like, this person was a forklift driver, they can't do that anymore, but they can go and be a traffic controller, somebody who holds up the stops. They've never done that before. So that is not reasonably within their education, training, or experience. So
they're very different to say a workers' comp, where you might be able to say, well, what else are they capable of doing? That's not the policy definition.
Not at all. Well, that's not the interpretation of the policies in the case law. Yeah. So the takeaway point is the person using, or can the person use, transferable skills which they've acquired through their education, training, or experience, and to do some other job. If there's no link, no connection, no transferable skills, never done it before, then the answer to that is that person is totally and permanently disabled, because they can't do a job can't is the wrong word, they're unlikely to ever return to work which is reasonably within their education, training, or experience. And I should say also here, sometimes the word unlikely does not appear in the total and permanent disabled definition in the policy. Sometimes the word unable appears. They are very different. The word unable refers to functional capacity only, whereas the word unlikely takes into consideration many other factors, for example, geographic location. If a person lives in a remote area, there is a high rate of unemployment, then that is a relevant consideration to the interpretation of the word unlikely. So is age, but in the use of the word unable, not so.
Okay.
So
just before we move on,
those questions.
Right. Just before we move on, and I know there's a lot of questions here, and thank you, keep sending them in, but there's one from Dr. Alan Galogli that I think really pertains to what you've been talking about in terms of, unlikely, unable, and the whole issue around education, training and experience. I'm going to turn the mic on for Dr. Galogli, putting you in the hot seat now, Alan, just to ask you a question around whether you could elaborate on how a medical practitioner could elaborate on that. So just, Alan, I'm going to allow you to, actually you can speak. So Alan, if you want to unmute and ask your question.
Thank you, Sue. Can you hear me there?
Yes.
We can.
Annemarie, thank you. We all get that question about education, training and experience, and I usually give an answer whether I consider it likely or unlikely, and then I usually back it up with a phrase like based on the severity of their condition and their prognosis. Is why I come around to that answer. Is that an adequate answer to opinion? Is the person is unlikely to work again because of their training experience and not qualified?
Alan, we're having trouble hearing you.
Did the guts of the question come across?
Only a little bit about, I know it's something to do with education, training or experience, but I didn't hear the rest of it.
What is adequate to back up that statement?
So I think the question is around how would you recommend that a medical expert back up in their assessment? What kinds of phrases would they use to back up their opinion on, in terms of whether they're qualified, unlikely to return based on their qualifications, education, training and experience? So given that they're not fully conversant with that person's background, education, experience and other roles, how would they, Alan, I think this is what you're asking, sorry if I'm doing you an injustice, but what would you recommend in terms of phrases or how a medical expert would make a comment around that if they're not exactly sure around the other,
yes,
where that education would lend itself?
Yeah, well, I think the first thing to understand is the duties performed by that person, so by the patient or the person who's coming for a medico-legal assessment. So understand what is involved in that person's job. Is it heavy physical tasks? Is sitting down? Are there sitting down, standing restrictions? I think apart from the actual criteria, I think it's important to understand the nature of the work and then try to consolidate those two issues. So know the history, and usually in a medico-legal report, as you know, there'll be a history, a background in terms of the person's family history, health, and also their educational vocational background. So that's what I would suggest. And then there are statements that are often used, like as you said, based on the severity of their symptoms, and this person is not going to be unlikely to be able to perform the heavy manual tasks of their role or their roles. That kind of thing is helpful. So I think you're doing the right thing, but I think it is important to understand the nature of the work.
And on that point, do you need to give a reference, like a textbook or research article? Are they required to do that?
Not at all. not at all. It's just your opinion, and it's your opinion as a treating doctor, for example, with the knowledge of that person's capacity, medical restrictions, and the sort of work that they've done before. So no, right. It's not. Okay. It's not that high level.
Thank you. Okay, we've got a whole heap of other questions, but I know we're still on TPD, so I'm going to let you continue and then we'll regroup. And thank you everyone for putting your questions in. I see them and we will get to them.
Thank you. I just wanted to say a little bit more about total and permanent disabled charitable claims. They need not be catastrophic injuries, and so if I could have the next slide. So, for example, I've had a fitter and turner who, and you know, some people might think this is a bit amusing, but it certainly wasn't for him. He injured his pinky, and some people might think, well, you know, big deal, you know, it's a minor injury, but it wasn't a minor injury for him because that's the only work that he'd ever done, and he needed the fine motor skills and, you know, I guess the dexterity and the balance of his hands to perform his work. So that claim was actually ultimately successful. So it doesn't have to be a frank traumatic injury, it doesn't have to be a catastrophic injury. It really is about the impact of the injury, whatever it is, on the future capacity for work. That's the underlining issue. And I think this goes to a couple of the questions that you may have received previously, Sue, that about the 50%, can somebody be successful in a total and permanent disabled claim but only do 50% of their role? Well, if a person is only able to continue to work because they have a sympathetic employer, well, that claim is probably an arguable claim because, again, is it a real job? It has to be a real job that the person is able to do. It can't just be a work task, for example. So if in a particular role there are numerous tasks that a person must perform, if that person, because of their medical restriction, can only perform one of those tasks, well, he's got an arguable case because it has to be a real job that the person, not a job that's created for him by a sympathetic employer, not a job where he can only do a work task. For example, I had a claim where I think someone, as part of his job, from memory, was sweeping the floor, and he couldn't do the other parts of his role. The sweeping the floor was sort of by the by. It was when he had nothing better to do. He was told to sweep the floor. He could still do that. Well, that's not a job. That is a work task. And so, again, is it a real job? Is there a connection between the previous roles and the future roles? What are the medical restrictions to prevent the person from working? So the short answer to that question is yes, that is a possible claim, even if they are able to do something. Is it a real job?
And maybe on that, there's a question here from Dr. Samari Jayaraja. Again, sorry, Samari, if I haven't quite understood the question, but I think it pertains to individuals who might be self-employed. So, you know, we self-employed people often, you know, do a whole variety of different tasks, and it may not be what you would, you know, be able to find on the open market. So questions, I guess, for self-employed who put in TPD claims, but maybe their skill set or education is not necessarily applicable to, you know, the broader market. Are there any scenarios there that you can elaborate on?
If you're self-employed and you're doing, for example, your own bookkeeping and you're doing marketing, the difficulty with that is going to be you've probably got a broad set of skills, and the insurer is going to look at that broad set of skills and try potentially to pigeonhole you into, oh, well, you can go and be a call centre operator. For example, you use the phone all the time. Why can't you go and do that? So, you know, they're the sorts of arguments that we have with insurers all the time. So the broader range of skills that a person has, the more difficult it's going to be. However, having said that, for instance, a surgeon, and this was actually an example in a very authoritative case in this area. So a surgeon who, I'm trying to remember all the details now, if that person injures his hand and he can't be a surgeon anymore, he might be able to go and be a ballerina. And it sounds like a ridiculous example because he can do that. He doesn't need, you know, those finite motor skills, but that's not within his education, training or experience.
And that probably answers one of the questions here from Dr. John Garvey. What if a surgeon who loses his sight and can't work as a surgeon, can that disabled surgeon then get a TPD payout? And that would say, well, yes, because he's no longer able to do a role that meets his educational, his education.
Yes, I wouldn't be categoric about it. I would say possibly yes.
Okay.
Because what often happens in those sorts of examples is that the insurers say, well, he can go and teach.
Right.
Well, he's not a teacher. He might have 30 years experience as a surgeon in the theatre, but he's not a teacher. So I would actually argue that he is TPD within his education, training or experience. Yeah,
and I think that's where it gets very difficult for medical experts who are not lawyers. It's definitely your role to take the information that a medical expert gives, but is it the medical expert's role to say, well, no, he couldn't teach? Yes, he could potentially train somebody, but that's not what he's been upskilled for. He's been skilled to be a surgeon in this instance.
I wouldn't even go that far in a Medicolegal report. I don't think that's the role of the doctor.
It's not.
No.
End up in a very dangerous scenario. So and so therefore what you're saying is that the questions is unlikely that the questions a medical expert would receive is going into any of that territory. They wouldn't be asked that question.
No, they're really interpretation questions, and the application for that there's sort of more, I would suggest that they're more legal questions.
That's right.
Based on the case law, because we're familiar obviously with how many of these definitions have been interpreted and the cases we can rely upon, which have gone to trial, and those that we've dealt with ourselves haven't gone to trial, for example. So I hope it answers the question about 50% or a person who's able to partially do a job, that they may actually be able to successfully claim a total and permanent self-pay. The only difficulty is that as the years have passed, the insurers have tightened their definitions. And so, as I said, Australian Super's insurer, which is TAL, and TAL is probably the biggest insurer in this area, they've got a really long and convoluted definition, which does include retraining, reasonable retraining, and reasonable rehabilitation. So if a person can return to work by undergoing reasonable retraining, that claim may fail. And when I say may fail, the insurers like to give, of course, a broad interpretation to the word retraining. However, it's got to be reasonable retraining. Again, there's got to be some sort of link. Surgeon, it's not reasonable retraining.
Fair enough. Okay, so we've still got a few more questions. I'll let you finish this section, but thank you everyone for your questions. It makes it really relevant.
Sure. So the only other few points I wanted to make on the type of claim, a TPD claim, is that it's not a claim based around how the incident occurred. So as I said, these are not compensation claims. So usually it doesn't matter how the injury occurred, whether it was at the supermarket, on the road, at home, at work, whether someone was negligent. Those kinds of considerations are actually usually irrelevant. So, of course, in the workers' compensation space, sometimes, there are arguments about, well, that injury didn't occur at work, or that injury was pre-existing and it was aggravated at work. Those sorts of arguments we don't normally have. So I just wanted to make that point that, they are different claims. And also the other point I wanted to make is that, and I think sometimes doctors do get a little bit maybe annoyed or cynical, or I don't even know the word, but perhaps they don't approve of clients or their patients who make multiple TPD claims. So they're asking for a number of reports because each of the insurers require their own pro formas. These people are not being greedy. These people have paid for insurance policies through their own money. And if the insurance policy allows it, some don't, but most do, they are able to make multiple TPD claims. So if you think about the superannuation funds you've been a member of, if, for example, you started work when you were 15, you worked at the local Woolies, you might be with Rest. Then you, like myself, you've graduated, and then you're a member of Legal Super. Then you don't like Legal Super for whatever reason, and you join some other fund. typically you can make a claim on each of those policies because you've paid the premiums. So people aren't being greedy. I just want to make that point because I think sometimes there is that sort of cynicism or sentiment, but I just want to clarify that they're paying for this. It's like if you have a fleet of cars, you've paid for 3 policies, why shouldn't you, and you have an accident unfortunately or somebody damages all 3 cars, why shouldn't you get them repaired by the
And that is a question Dr. Phil Sharp has asked, which I think you've just answered. If a person can claim multiple TPD benefits through multiple super funds or insurance policies, can the benefits exceed 100%? I guess the answer is, well, yes. It's each policy is standing on its own independent merits.
I have a client who unfortunately is very sick. She's made 4 claims on 4 different policies. And sometimes those policies can be within the same fund, by the way, maybe with different insurers. 3 of those claims have been accepted, 1 still under assessment. And there's absolutely nothing wrong with that. And it's all transparent, all the insurers know, it's all above board.
So just a couple of really quick fire questions before we move on to Medicolegal. I'm watching the time. Quick question was, and there's been some very patient participants here. First one was, sorry, they've been moved into the answered question. So here's one from Dr. Ralph Poppenbeek. If TPD is accepted and paid and the worker can obtain alternative employment, does the payout or benefit reduce by the income gained?
No.
Okay.
Unless we're talking about an income protection, that's a different scenario. But with a total, so if a person goes back to work in the income protection space to some work, there's going to be only a partial disablement cover. So I might have been unable to do any of my work. That would be total disability. Then I can go back to work because I've recovered somewhat, but I'm still not working full time. Then I'm going to get a partial disablement benefit if I satisfy the other criteria. With a TPD claim, what does happen is sometimes people recover even after their TPD payout. They go back to some sort of work, alternative work, for example. There will be no reduction. There will be no comeback. The only comeback is when a person is fraudulent.
Okay, thank you for that. I wasn't aware of that. Dr. Vinit Mathur, if a patient of depression refuses to undergo ECT, can he apply for TPD as the ECT may resolve the depression? So that comes back to that medical treatment that's been refused, and I guess that reasonable question. Is it a reasonable expectation?
Yeah, that's going to be potentially difficult for the claimant because the insurer is likely to say that they haven't undergone reasonable medical treatment and that they haven't reached maximum medical improvement. And so what may happen is that the claim will be deferred until that happens, or in fact denied. It comes back to, as you said, Sue, to that reasonable medical treatment.
Okay, and as an adjunct to that, again from Dr. Vinit Mathur, is there a minimum time required for treatment before the TPD can be applied?
There's no minimum time for treatment, but a couple of things. One, there's a waiting period, so the person has to be totally unable to work for 3 or 6 months usually. And in terms of treatment, you, the doctors, know this better than me. My understanding is that it takes some months and sometimes a year or for someone to be stable. It's not the same sort of issue stabilisation as it is for a workers' compensation claim. But if the person has not reached maximum medical improvement, that's a reason for the insurer to, in many cases, reasonably decline the claim or to defer assessment of the claim, because they just don't, because you can't really make an accurate assessment of the future capacity for work if the person still has to undergo reasonable medical treatment. Yeah. But we have many claims where the person has undergone a lot of medical treatment and there is maybe some other thing they can try, but we can't just keep going with the hope that somebody has, there has to
keep trying every treatment under the sun. Yeah.
Exactly. And certainly not experimental treatment.
Now, just as we transition into looking at the medico-legal component. Just had a quick question around social media and social media investigation, online investigation, which of course, have over time played a role in workers' comp kinds of arenas. Does that really happen much in this kind of arena? Is there much investigation? Absolutely.
Yeah. So we typically Google our clients.
Mm-hmm.
And we want to know if they've got an ABN, for example. If somebody's got an active ABN, well, question mark, why do you have an active ABN? If you say you can't work, that the two things are apparently inconsistent. And the insurers do it all the time.
Okay. Yep. Great. Okay, thank you for that. We're going to move on to looking at medico-legal, but I know that as we've been going through this, a lot of the medico-legal questions have been asked. So that's fantastic. It's actually about the relevance of how do I, as a medical practitioner, deal with this scenario. So thanks again, our amazing webinar audience. Keep the questions coming.
And
Annemarie.
I'm happy to go beyond the 8:30 time frame if necessary. I'm sorry, I'm sort of passionate about this area, so I probably talk too much, but I hope you're getting something out of it. So, all right, I'm going to restrict this to a medico-legal assessment. It also, I think, is important to note the treating doctor's reports. Very, very important. And some may say more important than the medico-legal assessment because the treating doctors know their patients, whereas a medico-legal has spent 45 minutes or an hour with that person. So the first thing that I would like to say about the medico-legal assessments, or let's just call it medical reports, is that these claims, whether they are income protection or total and permanent disablement claims, they are heavily dependent on the medical evidence. The strength of these claims rises and falls on the medical evidence. Without supportive medical evidence, the claim will fail. Now, how do you go about doing a medical report? The first thing is that you must be true to yourself. So the medical report must have integrity. It must be objective. You are not an advocate for that person. That's not your role. Your role is to address the definition. And what should be asked of you is, dear doctor, here's the definition. You won't be provided with a policy. You're not a lawyer. You don't need to interpret the policy. Here's the definition. Here is, sometimes, I don't always do this, here's other medical evidence that I can give to you to give you some evidence around what my client's been going through. But my position is usually, you're a doctor, you can make your own assessment about this person, and they can bring scans along and that sort of thing. Some of my colleagues, they give every medical report they've got. I don't normally do that. I give either what's relevant or sometimes not at all. You make your own objective decision. It is an opinion. It's only on the balance of probabilities. No one is going to come after you if you get it wrong. And what I mean by that is, if you give an opinion and that claimant goes back to work after having been paid $1 million, $500,000, whatever it is, no one's going to come back at you and say, why did you say that? That in all the years I've been doing insurance law, I've never seen that happen. And it won't happen unless you're being fraudulent. That's the only time somebody's going to come back and have a go at you. Otherwise, there is no concern around that. With respect to medical evidence, it is a claim requirement that medical evidence be provided. And that's why some patients, we send them to you, the patients come along, we need you to fill out a medical attendance statement. And that is a pro forma, which is required by all the insurers, which just has the personal details of the claimant, some basic information about their education, training experience, their duties, and then it asks you, is this person unlikely to return to reasonably suited work? It doesn't really say much else. And all you're required to do is to answer that question, give a diagnosis and a prognosis about the future capacity for work. And it is, as I said before, crystal ball gazing, but what you've got to do is, one, understand the definition. If you don't, ring up the lawyer. Two, what sort of jobs has this person done before? What are their medical restrictions? Is there a real chance they'll return to reasonably suited work as we said before. If you think that the report you're going to give is unfavourable, ring up the lawyer. If there's a red flag, ring up the lawyer. If you don't understand what to do, ring up the lawyer. So, for example, I spoke to one of my clients, treating psychologist recently. He didn't understand what he was required to do. He was worried. I can't say that you'll never go back to work. That's not what the question asks. It's unlikely. So it's not, is this going to happen? It's not a certainty. It's not a science. So you're just required to give an opinion. What do you think? And as I said, no one's going to come after you if you get it wrong. In relation to the AMA guides, most policies have various definitions of total and permanent disablement. The one that I've been talking about is what is referred to in the industry as the standard definition, but most have a number of other definitions. One of those other definitions, and the claimant doesn't have to satisfy all of them. As long as they satisfy one, they'll get up on their TPD claim. There is a definition which says if this person has suffered an injury or illness, been totally unable to work for the waiting period, be it 30 or 60 days, and they are at least 25% whole person impaired based on the AMA guides and unlikely to return to reasonably suited work, they are TPD. Usually that definition isn't considered because it's so harsh to meet all that criteria. It's actually usually irrelevant. Mostly the definitions we deal with are either the standard one or the activities of daily living one, which it talks about being totally and irreversibly unable to perform 2 of the 5 activities of daily living without the standby assistance of an adult person. So you don't have to be accredited to give an opinion on a TPD definition, except if it is one which does require an opinion about a whole person impairment assessment. Sometimes it doesn't even refer to the AMA guides. Sometimes it just said at least 25% whole person impaired. I don't know how you would assess it without the guides, but I've had one of those where they've said, this person has to be at least 25%. Well, on what basis? So that one got up as well. So I hope that I've helped you in relation to recourse, because I know that there is some, concern over the potential recourse if I get it wrong. And also, I mentioned the word trial a couple of times throughout this discussion, and that is a scary concept for all of us. I would not like to be in the witness box myself. These matters don't normally go to trial. Most matters either get approved or alternatively they get settled at some sort of intermediary stage within the course of litigation, or alternatively steps of court. Doesn't even usually go to trial. As I say, most matters, and I would say it's over 90%, get resolved before way before a trial.
Annemarie, just while we're talking about the whole person impairment, and I know you mentioned that rarely, the whole person impairment that's put in the policy over 25% is no one gets it. It's very hard to get, basically. I have a question here from Dr. Phil Sharp, and it's basically around, if the medical opinion doesn't actually impact on the amount of the benefit, why do we care what the percentage whole person impairment is? Isn't it more that they can't do the job? Why does the degree of impairment matter?
We only care because it's one of the definitions in the policy. So so if I read a workers' compensation Medicolegal report and it says there's 7% whole person impaired, well, I'm not even going to consider that definition. So you won't be asked it. And I don't recall. I think I've asked it twice in 12 years.
So you're saying that some of the definitions or some of the policies that put a WPI as part of the definition are so unattainable that they're disregarded. Is that right?
Well, they're usually, but the claimant can usually not meet that criteria.
Yeah.
And yet none of the opinions on any of the TPD definitions will impact the amount of the benefit. The amount of the benefit is fixed.
Okay. So probably, yes, devil's advocate, Dr. Sharp, it probably doesn't make a lot of difference what that figure looks like, what that percentage figure looks like. Hopefully that's answered that question, Dr. Sharp.
If the person is successful in the claim, they'll get whatever the insured benefit is. If they're unsuccessful in the claim, they'll get 0. So if a person...
Another question that's come in, what if, as the medical assessor, your opinion is directly contrary to previous opinions? I think that's what the question is, Dr. Sharwood. What if your opinion is starkly against the other? What's your advice there, if it goes against every other opinion that's gone prior?
That happens. It's not unusual. Really, it's the balance of the evidence. So if there's what I'll call an outlier, if most of the evidence says it says a particular opinion, provides a particular opinion, well, the balance of the evidence is in favour of that opinion. So the other opinion probably won't carry much weight unless it's the opinion of a treater. The opinion of a treater is really important, as I said before, because they know the patient. So again, it really depends who you are in terms of whether it's a treater. So if you're, the most renowned specialist in the area in Australia with that particular specialty, but really it does revolve around the balance of the medical evidence.
Yeah. Okay. And obviously, just looking at all of this, very much each insurer does things differently. And also policies change over time. I certainly remember the scenario where, the test for a heart attack, has changed, and often the policies are out of date, and you end up, talking about a test for a condition that is not actually even outlined in the policy. So they date. And I think as well, probably the other thing that I've become aware of is different insurers have different cultures around different, different illnesses and diagnoses, some around mental health where others don't even look at it, and they are a little bit more accepting of claims that present in a certain way. It seems that there are different cultures within different insurers.
Yeah, that's absolutely true. Over the years, for example, initially RSI perhaps wasn't regarded as a real illness. Then fibromyalgia or chronic fatigue syndrome was regarded as a diagnosis by exclusion, so there's a lot of cynicism around that. Then fibromyalgia, the same sort of thing. Mental health, not understood, perhaps a sort of black mark against anybody who had that, but it's more understood now. So there's much more sympathy in relation to mental health illnesses. In particular, there's not really any surveillance done anymore. In relation to that, because the people are very vulnerable. I agree with you, Sue, on that.
Okay. Another question that we've had, just from a lawyer's perspective, on who you choose to do medico-legal assessments, and this is a question that's come from Dr. Ron Thompson. And obviously, we've talked throughout this webinar on how valuable, how critical the medical opinion is in these claims, and that they aren't workers' comp claims, they aren't motor vehicle claims, they are very different. So does the experience of the medico-legal assessor in terms of the kinds of assessments they've done in personal injury and insurance law, does that impact on your choice of medico-legal assessor?
To some extent, only because we know the name, for example, we know the specialty, but it's really important to pick the right specialty. That's what really it's about. And in terms of someone who's done a lot of workers' compensation, medico-legal course, I would have no difficulty retaining someone like that, but that person has to be aware this is not a workers' compensation claim. You have to put a different hat on and address the definition, and not what you were looking at, whether this was caused by work or not.
Thank you for that. Okay, so where do reports go wrong?
So where reports go wrong in these sorts of areas, where doctors say things like, it is hoped that with future treatment, this person will be able to go back to work. Expressions of hope are unhelpful. The maybes, that equivocation, the uncertainty, again, I know it's crystal ball gazing, but those kinds of very broad, uncertain comments aren't helpful. Hope, in fact, there's case law around this, hope is not a relevant consideration for the assessment of this type of a claim. So there was a comment that I read in a recent medical report, and I want to read it to you to give you a precise example of what is unhelpful. So this particular treating doctor said, and I quote, "My hope would be that Mr. N can return to effective manual work in the future, but may have to avoid heavy physical tasks depending on his final outcome." Well, that actually doesn't even tell me anything. That's great. We're all very optimistic for Mr. N, but yeah, it's just not helpful. You're not telling me anything. You're not telling me, is this person likely to recover? Does this person have functional restrictions? Is there a real chance of returning to work? As I said before, the definition, the criteria to be addressed, the educational and vocational background, restrictions, medical restrictions. Is there a real chance this person will return to work? There's no probability. I can't give you a percentage of what chance means, but what I can tell you is the case law says that even if the chance of returning to work is less than 50%, that might be a real chance. So they're hard claims. So the expressions of hope are unhelpful. Where the doctor talks about every single modality of treatment that this person could undergo forever, unhelpful. What is the person's situation now? And with future reasonable treatment, will that impact on that? Do you think, on the balance of probabilities, not certainty, that treatment will impact on the person's capacity for work? Or alternatively, is it a means of simply enhancing that person's quality of life? It could be both, of course, but it would be helpful to know which, if it is only one. So we sometimes go back to the doctors and say, right, you've talked about this particular treatment, ketamine infusion or something like that. Well, do you think that is going to assist this person's return to work, reasonably suited work, or is it merely to be helpful
symptomatic
for
relief,
the quality of life?
Yeah,
the quality of life. So that's not helpful. Yeah. The other area which is really problematic is please don't talk about areas of specialty in which you have no specialisation. So, for example, if you are not a psychiatrist, then it's not helpful to talk about this person having to undergo psychiatric treatment. So that would be, if that did go to court, you'd be challenged on that because you're not a psychiatrist. So the other two things I guess that I've mentioned there are sort of the same as what we've said, just being very unclear and uncertain. If you're uncertain, ring up the lawyer who's asked for the report and have a chat to them. And we will talk you through what's required. What does the definition mean? They're not all the same, but they all have similarities. And we'll be able to assist you. And if you're not able to say one way or the other, okay, fine. That's what you should say. We are not going to tell you what to say.
And there's a comment here in the chat that's saying, really calling out the distinction in the role that you're playing as a medico-legal assessor in IP and TPD. It's not the patient-doctor relationship where you do look for hope and you look for, what is it that we can do to help this person's quality of life and help their outcome. With IP and TPD, it very much is around what are the real chances for improvement? What are the real chances that they can actually go back? And very much that calling out, it's a different role when you're doing these kinds of medico-legal assessments compared to doing a clinical interaction with a patient.
That's exactly right. And, in terms of, plaintiff lawyers, I've worked for both sides. I've worked for the insurers for many years. I've been on some people might regard the dark side. And I've worked on this side. And what I can tell you about medical reports is that we all want an objective report because we have obligations to the court. They are primary obligations, and we do not wish to be criticised or lose our practicing certificates because we've done something that's sort of sharp practice, let's just say that. So if you ever ring me up and say, Annemarie, what should I write in this report? I will say, I don't know. I don't know what you should write in that report. What I can tell you is what you need to address.
Yeah. Fair enough. A quick question before we just move on to permanent incapacity, and just for our audience, this is the last slide. So I know that some of you are probably tracking to have dinner or put kids to bed or whatever. Just this question is around, do policies, and thank you, Dr. Len, for posing this, do policies try to account for pre-existing conditions, such as, things that were present before the policy came into effect when they're paying benefits, and if so, how?
Sometimes yes. Sometimes that's one of the potential exclusions. So typically with a group life policy issued through a superannuation fund, typically no, but sometimes yes. But through a private policy, you would, or if you've applied for an increase in cover through a group life policy, you'll be asked a series of questions, health-related questions, and if you have got pre-existing conditions, they'll be excluded. And if you have more than, depends on the insurer. Some have 3, some have 5. If you have more than 3 exclusions, or as I said, depending on the insurer, 5, they won't cover you, or they won't agree to increase your cover. Too many exclusions, you're too risky.
Okay, so we're going to just move on to the last slide. So I'll just kind of give you a last bell, a last minute warning. If you've got any other questions, please put them in now. It's fantastic to have Annemarie. She's obviously a wealth of knowledge, and we're really privileged to have her here tonight. So please ask some questions as we're starting to get to the last topic, permanent incapacity certificates. Annemarie.
Towards the end of a total and permanent disablement claim, we will ask for permanent incapacity certificates. All they are is really similar to the medical attendance statement, where we just want you to tell us whether this person is unlikely to return to reasonably suited work. It doesn't have all the criteria that I've discussed before, because these are certificates required by the superannuation fund, not the insurer. So what happens, just very briefly, is if a TPD claim is lodged with the insurer makes a recommendation to the superannuation fund to approve a total and permanent disablement claim. If that happens, they will pay the TPD sum insured into the person's superannuation account balance. That TPD sum insured then becomes commingled with the account balance, and then the claimant has to satisfy an early release ground for that superannuation account balance, because they're not at retirement age, for example. And so in order to reduce the tax payable, permanent incapacity certificates are required. So that's what we are. And the only criteria is this person unlikely, because of injury or illness, unlikely to return to reasonably suited work, yes or no. So
that's true. Tax. That's often for that release of tax. Who is asked to do that? Is that a medico-legal assessor, or is that the treating healthcare practitioner?
It could be the medico-legal assessor, but it's usually the treating doctor.
Okay.
Treating GP.
GP often.
We do need 2 though, to effect the tax concessional rate, because otherwise people are paying about 22% tax. Instead of about 15%, so it's significant. We need 2 permanent incapacity certificates, and typically from 2 treaters. It can be 2 GPs, it can be 2 GPs from the same clinic, it can be a GP or a specialist. We do need 2 from 2 medical practitioners.
Okay, so is it likely that our independent medical examiners will be asked to do that if they're not the treater?
Not usually. Can be, but not usually. It's unlikely.
Okay. All right. So now is a call for any last questions that you might have before we wrap up. And I'd like to say, thank you for all of the questions. We've had a host of questions as we've been talking about different subjects, and it's been extremely helpful in terms of, helping us gain relevance and context to the words that you're saying, Annemarie. So I'm really, really appreciative of that. We don't have any other questions that come in, but I'm sure if there's anything that, as you're all lying in bed tonight thinking about the webinar, and all those questions are going to come, to the top of your mind at 3 a.m. in the morning, or maybe that's just me. But Annemarie, I would like to take a moment just to express our sincere gratitude to you for taking the time to share with us tonight. Your expertise and enthusiasm is extremely evident, highly inspiring, and I believe that I speak for everyone when I say that your knowledge on this subject is second to none. So thank you so much for fielding all of our questions. We've been really honoured to have you here talking to us tonight and giving us a better understanding of the context of the IP and TPD. I'm sure you'll have about, I think we had 56 attendees on tonight. You could well have 56 people who are vying to do work for you. So that would be fantastic, and who are trained by the best. So thank you so much for that. To all of our webinar participants, thank you all so much for taking the time tonight to be part of the webinar. your reports are vitally important in this function in helping to gain clarity on these IP and TPD assessments. And I really hope that the information that we've covered tonight and the questions that have been answered have helped you put a perspective, a context, a bit of an understanding on your role in here and how you manage different curly questions or scenarios that come up. So thank you so much for that. It's been my pleasure to have you all online tonight. And I really hope that we continue and have the opportunity to keep learning and growing together for future events. So thank you, Annemarie. Thank you to everyone who posed a question, and thank you to everyone who's been part of the session tonight. Have a great night, and we'll see you next time.
Thank you very much, and thank you for those great questions. Have a good evening.
Thanks, everyone. Good night.
Good night.
And yes, I can send the slides to everyone who's still here. I'll send a link tomorrow for access to the webinar. Thank you so much, everybody.